Hello, welcome again to the Tuesday Legal Updates with Andrew Namayaro from Tanlo Solicitors. Thank you so much for joining me today. I hope you'll be joining me again in the future. If possible, inform others that this program will be going on every Tuesday, every week. And if you have got any questions on the topics that you want us to discuss, please let me know. The contact details are there on the screen. May you also subscribe to our YouTube channel. We have got a channel. If you go on YouTube, look at Tanlo Solicitors, subscribe. We upload all our videos there, and there's a lot of videos that are available on that channel on YouTube. We also have a Facebook page, Tanlo Solicitors, which has got a lot of information that we put on there as well. So if you want legal information, visit our Facebook page where we put a lot of lead magnets, a lot of information, update people as things go on in terms of the law. Today, I've received three questions that I'm going to comment on. The first question is, can I bring a dependent if I am a dependent myself on a COS order? In other words, in this scenario, one parent holds the COS or the certificate of sponsorship, and they are married to someone who has got a child from a previous relationship. The question is, can that child come and join the parents who are the biological parent and the step parent? In a nutshell, the answer is yes, that child can come and join, provided that in terms of the other biological parent, they do not have responsibility over that child. How do we prove that they don't have responsibility of that child? It may be that they are deceased, or their whereabouts are not known, or they've got medical conditions um, that they cannot be able to look after the child by themselves. So in those kind of scenarios, the child can be able to come to the UK and join the biological parent and the step parent, and so long they are part of a family unit together. The other question that I've received is that what is the amount of money that is required under the financial requirement if I am to join a British spouse in the UK? So, if you are to join a British spouse in the UK or someone that has got indefinite leave to remain in the UK, it is a financial requirement that the sponsor should be earning £29,000 per annum. And we can prove that £29,000 by referring to their income in the last 6 months prior to the application. So the Home Office would want to see 6 months pay slips, 6 months bank statements, and a letter from the employer to show that the sponsor has been working and earning a pro rata amount of £29,000. If the sponsor is self-employed or is a director or a shareholder, the requirements are different. In that case, they will need to show, of course, the same amount, 29,000, but the evidence is different. The evidence could be HMRC tax submissions, the CT 600, personal bank statements of 12 months, business bank statements of 12 months, self assessment, and so forth. So that's the evidence that might be needed to be submitted if someone is self employed. So, an employed person, in terms of the evidence, does not have an onerous burden to prove the financial condition. But if you're self employed, there's additional documents that you need to submit. If you are not employed or you are not self-employed and you've got savings, the Home Office would ordinarily look at £64,000 of savings or rata. If you are working, you can mix income and savings together. There's a formula that the Home Office uses. And lastly, if someone is on PIP or is on the carer benefits, then they can be able to sponsor someone using those benefits as proof of income. Pensioners as well can now also sponsor someone as long as the pension, together with the income, meets the financial threshold to sponsor the spouse. Running through the news that we received this week, the Home Office or the government has announced that it's going to crack down on illegal immigration advisors. And there is a lot of people that are giving immigration advice when they are not qualified to do so and when they are not authorized to do so. So the Home Office is going to be issuing fines, and I understand that the fines will be in the region of about £15,000 if you are convicted of this offense. So if you want to give legal advice, make sure that you are regulated. You can be regulated under the IAA, or if you're a solicitor under the SRA, or if you're a barrister under the bar, chartered executive, SILEX. There's a number of regulatory authorities that are out there, but the main ones are that people that who do immigration is either the SRA or the IAA, which was previously known as the ORSC. I just want to encourage people that before you go to look for legal advice from a person, do your due diligence. Make sure that that person is authorized. Make sure that that person is experienced. So many people claim to have eh, the experience, claim to have the qualification, but it's easy to check. Go online, check their profile, go on the regulatory or authority website, put in their name, ask them whether are you regulated by the SRA or the IA, or tell us about um, which organization um, is is regulating you. If you do not do that, we have had situations and circumstances where people have been told that um, I'm a solicitor, I'm a lawyer, I do immigration, only to find out that they are not qualified and they've already messed up someone's case, or they've messed up your circumstances, and it's now difficult to clean up what they've done, or they've run away with your money. So I'm just saying, exercise your due diligence when you're dealing with people who say that they give legal advice, whether it's immigration, employment, or another area of law. But the Home Office and the government are going to be cracking down on people who think that they can give legal advice without necessarily um, having the proper qualifications. Another thing that came in the news is that the Home Office is going to expand the use of AI. Yes, the Home Office is going to expand the use of AI, and AI is taking over. The Home Office has been trailing the AI in making asylum decisions. Now they are going to roll it out to all, if not most, of the asylum decisions. So it might not be surprising that when you receive your asylum decision, it has been done by a computer. They are going to be doing this. They've said that it will help to clear the backlog, and it's going to make the system more fast in dealing with cases. Maybe the courts might also follow suit, but at the moment, it's the Home Office. They are going to be expanding the use of AI in making asylum decisions. We'll wait and see if the AI will make the decisions properly and correctly, or they will be prone to challenges. The third point in the news is that the Border Security, Asylum and Immigration Bill is going to be extended to exclude sex offenders from asylum. So if you have been convicted of a sex offense and you are seeking asylum, then the Home Office might not grant you asylum if this goes through, or if you've been given asylum, then and you are convicted, as usual, you will face deportation, detention, and removal slash deportation from the United Kingdom. You also be put on the sex offenders register, and it will be difficult to even get employment or to integrate with the community if you have got such conditions, or if you are on the sex register in the UK. So the Home Office in the bill is going to exclude sex offenders from seeking asylum or from being granted asylum protection. Let me just go through the charts. I think they've got some comments coming in. Okay, I will delete these chats which is sending things that are not relevant to what we are doing. Yeah. So I want to just comment on two things under employment law. Of late, I've been asking a number of people to help them with employment cases, individuals that feel aggrieved by how they've been treated by their employers and they want to take employers to the tribunal. Before you decide on taking the employer to the tribunal, if the relationship is still okay or it is relatively okay, you can try to talk together, try to negotiate, try to reason together, and you might come to a settlement. The good thing about a settlement is that it's less costly for the employer because you most of the times if it's a settlement agreement, lawyers will charge anything from 300 to 600 pounds, mostly if it's a settlement agreement. However, if a matter goes to tribunal, the cost will skyrocket into they will be calling to several thousands of pounds, and mostly it is the employer that will suffer a lot in terms of legal costs. If you want to take a matter to the employment tribunal, the first stage is that you need to approach ACAS for conciliation. And ACAS will help you to do conciliation. They'll take your case, try to negotiate with your employer if the negotiation works in or the mediation, as it is called, goes through, then the matter will not go to the tribunal. If it doesn't, then the ACAS will issue a certificate for you to go to the tribunal. You have got there are 3 months less 1 day from the course of action to take the employer to court. So there is a bit of technicalities that are involved there, and you need to understand in order to seek legal advice, particularly when the events that you've agreed to have occurred. For example, if it's an act, which is breaching equality, or it's a discriminatory act, then you need to take it to court 3 months from the date of that act happening. If it's a dismissal or anything to do with the termination of employment, then from that date. So ACAS, or rather, let's say settlement. If settlement doesn't work, then ACAS, mediation, and then take it to court. But you've got a window of 3 months to do that. The next thing that I want to comment on in conclusion is that if you are to do the ET1, the form for the employment tribunal, it is done online. You open an online account, you upload your documents, your information, you complete the form, and you add the details of your case, narrating what has happened, and stating what you are claiming. And at the moment, there is no court fee, so don't be scared if you want to take the case to court. You're not paying any fee; it's free. There's been conversations about court fee in the employment tribunal, but at the moment, it's not there. So when you are preparing for your case to go to the tribunal, in the first stage, when you're completing your ET1 or your particulars of claim, make sure you've got all the information, you've properly calculated the money that you're claiming in terms of, say, unpaid salary, unpaid leave, damages for urea, and so forth, whatever you are claiming for. The court uses what are called bonds, vendor bonds, etc., that you might need to be aware of. So this is my brief conversation or presentation to you regarding the updates for this week. Thank you so much for joining me, and I will be with you again next week. My name is Andrew Nyamayaro from Tanlo Solicitors. Please subscribe to our YouTube channel. Also like our Facebook page. Thank you.